From the Pep Radio Newsroom, these are the stories we are following today. Some of the nation's largest book publishers joined authors and parents of high school students in a federal lawsuit filed Thursday challenging a 2023 Florida law that increased scrutiny of school library books, arguing that the law unconstitutionally violates speech rights. Penguin Random House, Hatchet Book Group, HarperCollins Publishers, Macmillan Publishing Group, Simon & Schuster, and Sourcebooks alleged in the, the lawsuit that their books have been targeted for removal or removed from school libraries throughout the state following last year's passage of the law, House Bill 1069. The lawsuit challenges portions of the law that prohibit books with content that describes sexual conduct or pornographic content. The law imposes a regime of strict censorship in school libraries and requires school districts to remove library books without regard to their literary, artistic, political, scientific, or educational value when taken as a whole, the lawsuit said. Department of Education spokeswoman Sydney Booker on Thursday called the lawsuit a stunt and said, quote, "There are no banned books in Florida." However, HarperCollins publishers shared a press release on the lawsuit against the state after hundreds of titles have ended up being banned since House Bill 1069 came into effect. It explains the list of banned books includes classics such as Brave New World by Aldous Huxley, A Tale of Two Cities by Charles Dickens, For Whom the Bell Tolls by Ernest Hemingway, and The Adventures of Tom Sawyer by Mark Twain, as well as contemporary novels by best-selling authors such as Margaret Atwood, Judy Blume, and Stephen King. If a parent or a resident of the county objects to a book, the book must be removed within 5 days and remain unavailable until the objection is resolved. There is no requirement to review a book within a reasonable time frame or even to return it if it has been found not to violate the statute. If a book is returned to the library, an objector may request review by a state-appointed special magistrate at the expense of the school district. Novels by King, which have been reportedly banned, include Carrie, It, The Gunslinger, The Long Walk, and The Running Man. And King took to Twitter on August 31st to react to the news, simply writing, and we paraphrase here, "Florida has banned 23 of my books. WTF." In a victory for trans students' rights to privacy and autonomy, the New Hampshire Supreme Court today affirmed a lower court's ruling that upheld a school district's policy respecting students' personal pronouns and maintaining student privacy when appropriate. The court concluded that the plaintiff, the mother of a student in the Manchester School District identified only as Jane Doe, failed to demonstrate that the policy infringes a fundamental parenting right. In their opinion, the court went much further, shutting down definitively the mother's claim that the school's policy respecting students' privacy infringed on her ability to properly parent her child. The policy, the court wrote, does not prevent parents from observing their children's behavior, moods, and activities, talking to their children, providing religious or other education to their children, choosing where their children live and go to school, obtaining medical care and counseling for their children, monitoring their children's communications on social media, choosing with whom their children may socialize, and deciding what their children may do in their free time. In short, the policy places no limits on the plaintiff's ability to parent her child as she sees fit. School districts across the country have been battling far-right school board members and their allies in turning back privacy protections for LGBTQ+ students and trans kids in particular. Meanwhile, in Ohio Attorney General Dave Yost has filed a response to the American Civil Liberties Union's appeal challenging the recent court ruling that upheld the state's ban on medical interventions aimed at transitioning the sex or gender of minors. House Bill 68, which was the subject of the ACLU lawsuit, prohibits surgeries and medications intended to alter a child's sex or gender. It also preserves the integrity of female sports teams and safeguards parents from losing custody if they do not support their children's transition efforts. On August 6th, Franklin County Common Pleas Judge Michael Holbrook ruled in favor of the state, affirming the legality of House Bill 68. The decision followed 5 days of testimony and written arguments from both parties, culminating in a judgment that allowed the law to take effect. The court's decision was well-founded, reflecting the evidence and upholding Ohio's protective measures for children, said Yost. He emphasized that the law was enacted by Ohio's elected representatives with the intent to shield, quote, vulnerable minors and ensure fairness in women's sports and uphold parental rights, yada, yada, yada. The appeal continues as the ACLU challenges the constitutionality of House Bill 68, asserting that it infringes on individual rights. And that's today's top LGBTQ plus news stories. Now back to the music here on PEP Radio.